morning, everybody. Welcome to Law and Crime. I'm Jesse Weber, and thanks for joining us here on the program where we cover the most interesting live trials and legal stories in the news today. And today we have a lot to talk about, so let's get started right now. Okay, let's break this down right now. And joining me is criminal defense attorney Eric Johnson. Eric, great to have you back here on Law and Crime, and I want to get right into this case with you. Based upon this witness, what it seems to me is that Mr. Merritt was very shady about this money coming out of the McStay family, and that he might have been up to no good. What did you get from this witness so far?
Well, I do believe that Mr. Merritt had some financial troubles and that there may have been some discrepancies with his accounting methods with Mr. McStay's account. However, none of these things, as the defense surely is going to point out, makes him a murderer. I mean, simply the fact that he has some type of financial issues that are going on at that time does not necessarily mean that he would rise to commit a murder of this fact, and not only commit the murder against Mr. McStay, but also against 3 other family members. That's pretty excessive for pretty much $21,000.
I've seen people kill for less, but then again, we're going to talk more about it. Let's play more of Susan Heckerman, who is, again, this is a McStay business associate that had these dealings with Merritt, brought out by the prosecution for a reason. Take a look.
I'm afraid that those...
That was in May, early May.
And you indicated that at one point he had said he was in the hospital as well?
Yes.
Do you recall when that was?
It was after he said the water features were available, they just needed to be created and sent to us, and then shortly after he said he was in the hospital, I believe, for a couple weeks and would not be getting out, so we couldn't get the water features.
Now, at some point, did you have a conversation with your boss, Mr. Martin, about the difficulty with getting the fountains?
Yes.
And what, if anything, did you do in terms of trying to get the fountains after that conversation?
I kept a record of every time I spoke to somebody within that organization. Each time a check was written, each time there was conversation, there was an email, and Jeff had asked me to just get in contact with whomever I can to get the water features. We didn't want to start all over because we had a building to open for our clients, and we needed the water features to finish the building.
Is that when you got in touch with the San Diego Sheriff's Department?
Yes, my boss had asked me to do that.
Okay. Now, you mentioned earlier that the defendant had asked for additional funds. I'm going to show you what's been marked as 771 and see if you recognize this.
Okay.
Do you recognize that?
Yes.
Was that a document that you had received?
I don't know if we received it or if we created it so we could get the water features.
Okay, Eric, if the prosecution can successfully prove to this jury that Mr. Merritt took $5,000 from Joseph McStay's mother to complete a project but never paid her back, if they can prove that he wrote himself $21,000, over $21,000 worth of checks after the McStay family disappeared, if they can prove that he forged checks, that he impersonated Mr. McStay from the QuickBooks account even before the family went missing, if that he was engaged in this very shady financial dealings, is that strong enough, in your opinion, to say, hey, there might be not a ton of forensic evidence pointing to this to him to this crime, but there really is a strong motive here?
Well, I wouldn't even necessarily, as a defense attorney, I wouldn't say that it's a strong motive. It is a motive. Financial gain or the attempt to absolve a debt is definitely going to be a motive. However, when you look at the totality of the circumstances, you not only have to look at Mr. Merritt's dealings with Mr. McStay, but also his total financial picture as well, to see if this was something that was specific as it relates to Mr. McStay or overall showing of his financial instability. Now, while he did have a gambling problem, the issue would have to see, was there any foreclosures? Outside of his debts to Mr. McStay, did he have a lot of other debts that would show that he had a great need for money? And given the fact that the money that was obtained in this matter, the state would possibly only be able to prove $26,000. If that is only a small proportion of his debt that he may have amassed, that still is something that the defense should focus in on to say that, hey, I owe all this money. I'm not just going to kill this guy for $26,000.
Yeah, you know, we're going to talk more about it, what it's like to be in his shoes, gambling, was in debt, what was it like to be Mr. Merritt. And we'll talk more about this and the motive and also the defense's theory that a third person, a man named Dan Kavanaugh, is the actual person who did this. We'll talk more about that right after our next break, so stay tuned here on Law and Crime. We'll be right back. Everybody, we're still talking about the McStay family murder trial. We'll be live there at around 12:30 p.m. Eastern Standard Time today, but right now we're recapping the testimony that you might have missed. And yesterday we were talking more, or in the courtroom they were talking more about motive here. Remember, the motive put forward by the prosecution is that Mr. Merritt killed this family for financial gain, that he was embezzling money out of the McStay family business. And where we last left off, we were playing you the testimony of Susan Heckerman, who's a McStay business associate, and she was called by the prosecution to talk about the fact that Mr. Merritt kept asking money from the McStay business, and he was shady with that. In fact, we learned earlier on in this trial that he had asked Joseph McStay's mother for $5,000 to complete a project and never paid her back. So what happened when this witness went under cross-examination by the defense? Well, she mentioned one person that's worth noting. Take a look.
Bottom, and it says $12,750. Is that correct?
Yes.
And this was an invoice from Earth Inspired Products to your company, correct?
That is correct.
And the date of the invoice is February 2nd, 2010, in the upper right corner?
Yes.
Okay. But you don't know when this invoice was generated, do you?
I've seen this invoice when I got involved. I can't tell you what day it was created.
Objection, foundation.
My question is, you don't know when Earth Inspired Products would have typed up this invoice, do you?
No, I can't say I know when you typed the invoice.
What about the date that your company would have received this invoice? Do you know when that would have been?
No.
No?
No,
Okay.
I wouldn't know.
But is there anything on this invoice to show that your company paid the invoice to Earth Inspired Products? Do you know where this payment was sent to?
I'm reading this as a receipt. If you go back to the top, keep going, it says receipt for a 50% deposit.
Okay. So this is EIP, or Earth Inspired Products, saying that they got the $62.50, correct?
Yes.
Okay. And this receipt was sent to your company, correct?
Yes.
Okay. Which means your company sent it. Do you remember when your company sent that $62.50, which would have been half the cost of the waterfall?
No.
Okay. I'm going to show you, see if this refreshes your recollection. This is a bank statement of Daniel Kavanaugh. You can take a look at it.
Speculation, foundation, lacks facts, not in evidence.
Sustained on foundation.
Now you can take a look, with the court's permission, at that document to see if it refreshes your memory as to when your company sent the $62.50.
Objection, foundation. Assumes facts, not in evidence.
Well, she can look at anything to see if it refreshes her recollection, regardless of what it is. So the objection's overruled.
I wasn't part of this at the time. I mean, I can read here and tell you when this statement says that they received.
All right, so Eric, you know, really, we're getting that. We just heard the name, Dan Kavanaugh. Again, that person that the defense is saying is really the killer. They're trying to introduce him. Let me ask you a question. In your opinion, based upon what we've seen so far, is that a viable suspect, Dan Kavanaugh?
Well, I mean, based on what we've seen thus far, you can't say that Mr. Kavanaugh is a suspect. All you've seen so far is that Mr. Kavanaugh is involved in the trail of money and how it's been transferred amongst these partners. The issue that you'd have to get into is the fact that you want to establish that there's at least one other person who may have a financial motive to kill Mr. McStay. So then, because if that is the case, if you're able to identify that, then you can't say who would have more likely killed them. Then you have to turn to the other evidence, the forensic evidence, because if you have multiple people who had a financial motive, there has to be something more, especially if the state is just relying on the financial motive as their main piece of evidence.
And it's interesting that the defense is saying, yeah, there was a financial motive here, just not on the part of our client. It was on the part of this guy, Dan Cavanaugh. Let's play more of Susan Heckerman, this McStay business associate, when she was under cross-examination.
Contacted Mr. Merritt. Did you know that Mr. Merritt was a separate entity aside from Earth Inspired Products?
Objection, speculation, assumes facts, not in evidence.
Oh, she can answer if she knows.
No.
So you have no idea what the financial arrangement was between Earth Inspired Products and Chase Merritt, do you? You have no idea.
Objection, speculation.
Sustained.
After your testimony was that you get involved when there's a problem, correct? With the subcontractor?
Yes.
Would it be fair to say that before you contacted Chase Merritt, you had been contacting someone else at Earth Inspired Products, correct?
Yes.
Who was that?
I was going through the emails and the contact information on their website.
And that, do you recall speaking with a Dan Cavanaugh?
I do know I spoke with him. I believe I spoke with him after I spoke with Chase.
Sorry to do this to you. Have you refreshes your memory as to what you told the detective?
Okay.
Did you not tell the detective that you sent the money to Dan Cavanaugh? You can look at that first. Well, you can look at the...
I didn't send any money. That was not part of what I did.
I'm just asking if you told the detective that, if that refreshes your memory.
Objection, hearsay, lacks foundation.
Sustained this phrase, you've asked her to review the report, so that refreshes the recollection.
Does this refresh your recollection as to what you told the detective?
I said they being my company,
Right.
sent the money.
To who?
Objection, hearsay.
Okay, let's talk more about this. Eric, based upon what we've seen so far, is it at least clear that whoever did this to the McStays knew them, that it really doesn't seem like a crime, like a stranger did this, but somebody that had access to them, that knew where they were, that had a relationship with them, based upon what you've seen? You think that would be accurate?
Well, I mean, I think that would be possible. That could be construed that way. However, given the brutality of the crimes and also the lack of what we really know about the case, I mean, we know that they were seen, the family of four was seen walking into Mexico. So how do we get from there to the shallow grave in the middle of the desert? I mean, a lot of factors are going there as far as we may have to get into some more of Mr. McStay's personal business to find out exactly what happened. But the fact of this, the way that this crime went down, doesn't necessarily, to me, say that it had to be somebody that they knew personally.
Well, the prosecution wants to say that the killings happened in the house, and then, the bodies were moved to the Mojave Desert. The interesting thing is we saw the medical examiner testify yesterday, and we're going to talk more about that, where maybe the presence of these injuries, was there bleeding, was there not bleeding? I mean, the real big thing the jury has to decide at the end of the day is, where did these killings happen? And I think we have to really understand that. So I'm being told we have to take a quick commercial break, but I do want to talk to you more about this on the other side of the break. So we will be right back, and when we come back, we're going to play the testimony of Jeffrey Martin, another business associate of Joseph McStay. We'll be right back. Welcome back, everybody. We're talking about the Charles Merritt case, the McStay family murder trial. We are going to be live in that courtroom at 12:30 p.m. Eastern Standard Time. But in the meantime, we're recapping testimony that you may have missed. And right now, we're trying to understand about the defendant's financial dealings. What kind of guy was he to be in business with? Well, based upon the testimony of the next witness, Jeffrey Martin, who is a business associate of Joseph McStay, Mr. Merritt, not a great guy to be in business with. Take a look.
Do you know where those funds actually went or who they were paid to?
Well, they were paid to the company.
I'm going to show you a couple of invoices. 768 and 769. Do you recognize these two particular documents?
Yes, these are this is the quote and the initial invoice for the fountains, and then the 50% down payment receipt.
Okay, so the 769, which was the first one we were talking about, you indicated that was the actual quote that your company received?
Correct.
Now, on this particular quote, we see a date of February 2nd. Now, after your company paid these additional funds, do you recall actually receiving the fountains?
No, we continue to have difficulties getting the fountains.
And who was your contact with at that time with respect to trying to get the fountains?
My conversation wasn't with Mr. Merritt. I had other people in the office that were, I'm sure, talking to him, and maybe somebody on the shop floor.
Speculation.
Did you actually eventually get the fountains?
We did. We ended up having to send one of my superintendents out with a truck and a check to get the fountains on the truck. And
did you ever contact Mr. Merritt to attempt or file a lawsuit against Mr. Merritt to attempt to recoup your funds?
I did not.
All right, Eric, at the very least, not a great guy to be in business with, but at the very most, he had a motive to kill. The question that we always keep asking is, we say, well, why would somebody kill for only a few $1,000s? But isn't the other way of looking at that? We've seen people kill for all different kinds of reasons, and even for a lot less?
Well, yeah, I mean, you have seen people kill for a lot less money than that, but generally there's some kind of extenuating factors in that. I mean, when you look at low-level crimes, I mean, most of that is based out of need, necessity, or some type of substance abuse. When you get up to higher, more complex crimes, and this type of white-collar crimes, basically embezzlement, you don't really see it. A lot of those people don't have violent tendencies. So the fact that there may have been a financial debt, I mean, given the fact that the society we live in, everybody owes somebody something. But we don't have, everybody's not getting murdered for that every single day.
Yeah.
So just because of the money. So, I mean, while it can be shown as the state to be a possible motive in this matter, I think that the defense is going to accept that, relate that to the jury, but also require the state to have something more than that, especially when there's the possible presence of a third party who may have also had a similar financial motive.
Hey, listen, we're just all trying to find answers to what happened to this beautiful family. Really just horrific watching these videos of these innocent children. Let's see what happened, though, when this business associate was under cross-examination by the defense. Take a look.
It's addressed to somebody, correct? I think it's the name you just mentioned.
Yeah, Christina Martini. She's was an interior designer for us. She's no longer with us.
Okay, but that would be the person that would have, at least based on your knowledge of how your company works, would have had the contact with Earth-inspired products?
Correct.
Okay, and that person would have done, Ms. Martini would have done the, I guess, the work related to getting this first initial invoice to your company, correct?
Correct.
All right. And so, do you know who she was in contact with at Earth-inspired products?
I don't.
Were you aware that Mr. Merritt, the person that you were speaking with, and that was sometime later, correct?
Correct.
That he is not an employee of Earth-inspired products?
Objection assumes facts not in evidence.
Objection sustained calls for speculation by this witness.
Do you know what Mr. Merritt's relationship was with Earth-inspired products?
Objection speculation.
Well, if he has a basis for answering.
The conversation I had with Mr. Merritt indicated he was a partner.
A partner with Earth-inspired products?
Yes.
Okay. And why would you make the checkout then to Charles Merritt as opposed to Earth-inspired products, or?
Would it have been after Miss Heckerman, Susan Heckerman, would have contacted Earth-inspired products, or would it have been before?
I'm sure that it was after Susan had conversations with Mr. Merritt and Earth Inspired that it finally got to my desk as an ongoing issue.
So usually the president's the last one to deal with the issue.
Correct.
Okay. So it was some time later, and your conversations with Mr. Merritt went something like Mr. Merritt telling you, hey, I haven't got any money on this. If you want me to build your waterfalls, you need to send me some money, correct?
So, Eric, as we still learn about the financial dealings here between the defendant and the victim, and we're also talking about Dan Kavanaugh, we're all trying to understand this. The idea, you tell me from a defense perspective, they can't argue financial motive makes no sense in this crime. How could somebody kill an entire family for money when they're saying an alternative theory is that Dan Kavanaugh did this same thing because he himself was in debt and was cut out of a major project in favor of Charles Merritt. So I'm curious, the defense has to be really careful about how they argue this, correct?
Yes, that is correct. You don't want to lose any credibility with the jury. And as I stated before, the defense is going to have to accept the fact and relate to the jury that they do, in fact, accept that fact that financial situations may be a motive for murder. I mean, that's common sense. I mean, you're not going to deceive the jury by trying to go down that line of questioning or statement or theory of the case. But in this particular situation, what they want to do is establish that there may have been somebody else that had a financial motive, in addition to the lack of forensic evidence specific pointing to Mr. Merritt in this case. Because all they have to do is create a reasonable doubt that somebody else could have done it, or that the state has not proven to them that Mr. Merritt is the one who did it. That's what the defense's purpose is in this case.
And Eric, without that financial motive, and we know motive is not an element of the crime, would the prosecution have still gone forward with charges? Do you think they would have a strong enough case without it?
Well, I don't really think they have that strong of a case right now with it, but I do think if they didn't have that particular piece of evidence, they may not have been so vigorous, and they may have offered some more favorable pretrial resolution for Mr. Merritt to where it will prevent from getting to this point.
Yeah. So it's really interesting to hear this back and forth about, talking about finance, but we got to now get into the forensic evidence. So let's take a quick break. When we come back, we're going to play you the testimony of the medical examiner who testified yesterday, and there's a lot to discuss. We'll be right back. Welcome back, everybody. We're talking about the Charles Merritt trial, which we will be live in at 12:30 p.m. Eastern Standard Time. But as soon as we have an update in that courtroom, if something should happen, we're going to make sure to go there. In the meantime, we have to talk about what happened in court yesterday. And we saw the testimony of the medical examiner. Very difficult job, especially in this case when you're dealing with 2 young children, 4 victims, a whole family brutally killed and left in the Mojave Desert. But she provided very important analysis about where these murders may have occurred. So let's play her testimony for you right now.
All the bones are white, bleached, and dried and flaky. There's some brown discoloration on one of the rib and top of the bones.
And moving on to the actual next exhibit, which would be 351. Did you find anything significant about this particular portion of the skull that was remaining?
On this frontal bone, we see a circular or half a circle defect on the back right side. The cause of this is unknown. There's also a fracture or broken piece of bone here on the right side, and this fracture determined to be not perimortem. The top of the skull, again, you see the same half circle fracture here on the left frontal bone, and the area that was dark in the picture is actually this area, the left back side of the head. Also looks like a half circle, and you can tell that even though there are no bones in this area, that there was a impact here because of this piece of skull. It's triangle shaped with a circular base that is broken but still attached to it.
Now, are you able to determine exactly how many impacts or strikes caused these injuries?
Because there's no soft tissue on these bodies, you can't tell exactly how many impacts. Because you can have a force put on your head that doesn't cause skull fractures, and it only causes either bruises or the scrapes or laceration, as we talked about. So those are also impact site. So on these cases, I can only say what's the minimum amount of blows to the head that was found based on the fractures that we see on the skull.
And what would that minimum number be?
For this case, the minimum number.
Okay, Eric, this was a huge witness because basically what we understood was that it may be possible that this family could have been beaten with the sledgehammer and that there wouldn't have been this massive blood loss, which is interesting because if that's the case, then isn't it possible the killings happened in the house where there really wasn't any blood or any sign of a struggle or any sign of an attack? I'm curious your perspective.
Well, definitely. The fact that the state is promoting the blunt force trauma as their method of death in this particular case, that basically gives you the belief that there's going to be a lot of blood somewhere. And the fact that it's not found in the home means that this may not have happened at the home. And what we also know is that the fact that you saw the family of four walking into Mexico also shows that it possibly didn't happen at the home. One other thing is the fact that these bodies were found 3 years after the fact. As you heard the medical examiner mention, there's no soft tissue on these bones. So I think the defense also should go and try to point out, get the medical examiner with their line of questioning to show that there may have been another cause of death because we don't have the organs, we don't have the tissue, because you were shot in the chest that would have nothing to do with fractures in your skull that may have come out or something else. You don't know if these bones have been manipulated by animals or if they've been just weather beaten or anything else like that over a 3-year period. So the fact that these, that they're estimating that there may have been 4 strikes to the head, I think the defense would also like to put up that there may have been possible other ways that they may have died in this case.
Well, she said she couldn't definitively say that the sledgehammer was the murder weapon, although it is curious that it was buried with the bodies. One other thing to note is that under cross-examination, she said there would be a pool of blood when referring to the injuries of the skull. So, but that idea was thrown to the jury. At least they now have the understanding of maybe there wasn't a lot of blood. And really, if the prosecution can show that the killings did happen at the house, that is a much stronger case against Charles Merritt than before, correct?
Well, I mean, I don't see how they would be able to show that the murders occurred at the home, given that there was no forensic evidence found at the home by anyone at any point in time during this investigation.
Well, there was a little bit of blood spatter. Well, what they tried to say was blood spatter. The lead investigator says he doesn't believe the killings happened there, but he also said it could be possible blood spatter. That's one thing we saw.
Well, when he said possible blood spatter, what we're looking at, you're talking about a significant loss of blood from 4 human beings. So I think that there would be a significant more than a little bit of blood splatter if if the murders took place at home. And there's also no evidence of any type of cover-up. They didn't find any chemicals or anything that may have been used in trying to cover up the crime.
Well, they found paint. They found paint. Then there might have been an issue of whether or not the paint was used to cover up anything. And if there wasn't a lot of blood loss, maybe that's all there was.
Well, I mean, given the fact that you're saying the blunt force trauma, it's impossible for there not to have been a lot of blood loss. Given that you're talking about hammering 4 humans to death, 2 of which you would assume would be fighting for their life at the time, being the adults. So unless they're saying that, and I don't believe there's been any evidence that he had some other people with him, to assume that one person bludgeoned 2 adults and 2 children to death, and the only blood that you see is a little bit that's on the television. I mean, so did he kill them all in the exact same spot in the house? Did the bodies all fall in the exact same spot in the house? Were they all facing the same way? Did the blows come from the same way?
And you know that the order of how they were killed is something that we're going to have to discuss because that becomes a big issue. Let's take a quick break. When we come back, we'll have a lot more to talk about.
I have not called him a single time that it didn't go to voicemail.
Oh, so every time you call him,
It went to voicemail.
it goes right to voicemail. He
Well,
doesn't answer his phone.
He didn't answer his phone, but every time I stopped trying to call him, I don't remember what day, but I don't even remember what day, but I stopped trying to call him because Mikey or his mom or somebody had told me his message box is full. Okay? But the last time I tried to call him,
All right, let's break this down right now with criminal defense attorney Eric Johnson back with us. So we'll talk more about whether it was a good idea, a bad idea for him to, be interviewed by the police without a lawyer. But my first question is, when you're sitting on a jury and you're waiting to see if the defendant will testify, that's one thing. But to have a police interrogation tape played for the jury, what does that do for them that maybe they wouldn't have had otherwise?
Well, really, they're looking to try to hear and understand the person's demeanor and see if they'd say anything that convicts them of the crime, that basically puts them there as something that doesn't make sense. That's what the jury is looking for, to see if what he's actually saying makes sense, because that may be the only chance that they get to really determine the defendant's credibility in this case, because, as I said, there's a great possibility that he may not testify himself.
And at the very least, he seems to have, during this tape, to criticize both Summer and the boys, which I'm sure his defense team is not too happy about.
Yeah. Well, I mean, you definitely don't want to paint any bad light on the victims, especially if you didn't have anything to do with it. But what he also needed to do is to come off in a normal, candid way. So if he's describing the things that he saw with the family as far as her behavior with the kids or some of the things that he may have seen with the kids, that kind of humanizes him with regards to his relationship with the family. So he doesn't want to come off disingenuous in any way, but also wants to walk the fine line without being disrespectful.
Normal and candid. I'm glad you mentioned that. We're going to see that on the next side of the break, some interesting comments that he made during that police interrogation tape. Let's take a quick break. We'll be right back. All right, Eric, let me ask you the question I've asked other people. Is it suspicious? Is it strange that Charles Merritt would be using the past tense to describe Joseph McStay only less than 2 weeks after he disappeared?
Oh, not at all. I mean, and I think that the tactic used by the investigator in that man is basically just that, a tactic trying to trip someone up. She's asking him about past events. Obviously, this gentleman, Mr. McStay, had been missing for 13 days. I mean, what happened to a person assuming the worst? So if he assumed the worst and he assumed that something may have happened to him, that could influence the way that he referred to the situation. That doesn't necessarily mean that he had anything to do with it. So I think that by focusing in on that, that's a real insignificant fact that the state is trying to prop up to give more importance to the jury, that the defense is definitely going to have to address and minimize in their cross-examination as well as closing.
Well, let's listen to what the defendant had to say more about Joseph McStay and his feelings toward him. Take a look.
Super nice guy. I mean, he'll give you the shirt off his back. I mean, he'll do anything for you. And Summer's just the opposite. You know, she's well, I don't know so much about that, but she won't give up anything. You know, what's hers is hers, and what's hers is going to stay hers. And Joseph is more like, you need what? There you go. Oh, I mean, I've got, mine and Joseph's running tab is $10,000. He owes me $10,000. I owe him $15,000. If he owes me $5,000, I owe him $15,000. It just goes. And Summer never liked that, because it was just always a running tab. If I needed money, I pick up the phone and say, hey, dude, I need a couple of $1,000. If he needed something done, he picks up the phone. Hey, dude, I need, and we got it done. Whatever it was, we got it done.
Are you having any financial problems?
We've been having financial problems for 6, 7 months, 8 months.
Why is that?
Well, it's just business has been, it almost dropped right out from under us for like 3 months. There was almost no sales at all, and then it killed us financially. My heart attack didn't help much.
That's some of the defendant's police interrogation tape from 2010. Eric, let me ask you, after we couldn't play the entirety of it, but we did play some key moments, based upon what you saw, did this help or hurt his case?
Well, I don't think it hurt. I never think that the defendant speaking to the police or testifying when you don't have to helps in any way. I mean, it can only hurt. So I just don't think that it hurt him too bad. I mean, in this situation, he described possible financial difficulties by Mr. McStay, a financial situation between the two of them that would possibly explain the $21,000 that the state is alleging in this case. So it helped him along those lines. Without hearing all the rest of the testimony, there may have been something that the state may have brought out that may have incriminated him. But based on what we heard, he didn't do too bad at all, and actually may have gave his defense some other points to attack.
Now, let me ask you, a lot of people are saying that there's not enough against the defendant here. And if you were sitting on the jury, we believe this trial is going to last for months. What do you want to see from the prosecution? What do you need to say there's more concrete proof against this guy?
Well, if I was a juror, I wish I ever had the opportunity. I probably wouldn't get selected. But if I was on the jury, I would want to point to something showing that he committed the crime. I mean, there's a lot of circumstantial evidence here, but as the defense is cultivating their theory of the case, that creates circumstantial evidence for the other way. And given that the standard of proof is beyond a reasonable doubt, the state is going to have to show me beyond a reasonable doubt that there is something tying Mr. Merritt in to the actual death of these individuals. Without that, then it's just mere speculation. And I probably wouldn't believe the evidence was sufficient to convict.
And listen, we are looking at all different kinds of theories. We're speculating about what happened because maybe we don't have those concrete answers, but the prosecution is still building their case and they have more to go. We expect to be live there later on in the afternoon, and we'll obviously update you once we have that feed. In the meantime, let's take a quick break, and when we come back, we're going to talk more about where those bodies were found. We'll be right back. Welcome back, everybody. We're talking about the McStay family murder trial out of California. This is the trial of Charles Merritt. We expect to be live there at 12:30 p.m. Eastern Standard Time. And right now we are recapping where we are in the case. We talked about motive. We talked about his police interrogation tape. And now we want to focus on the bodies that were found in the Mojave Desert, in those two shallow graves. Our very own Kathy Russ, an executive trial producer here at Law&Crime, was reporting from those that gravesite, and now we're trying to understand what happened to this family. We saw the testimony of Detective Edward Bachman, a lead investigator from San Bernardino, who helped elaborate a little bit more about what was found. Take a look.
We heard from Sergeant Avila about the documentation of some, I'm going to use the term loosely, tire impressions in the dirt area near grave A and B. Were you shown those?
I was.
Okay. Did you happen to examine those and get familiar with them?
I did.
So we heard from Sergeant Avila the approximate measurements of each and their location to grave A and B. What I want to ask you is something different, which is when you're looking at it in the context of the scene, what was significant to you about them?
Based on the layout of the tire impressions, it appeared that the soil at the time that they were caused would have been soft because they sank down below ground level. At the time when we drove out there, the scene was dry, and there wasn't a noticeable depression in the ground like there was when we examined the tire impressions that we believe backed up to both graves.
So is depression a better word than impression?
I would say so, yeah, because it's something that's pushed down into the ground.
Based on that observation and opinion, did you do any research about weather conditions on or near February 4th, 2010?
We did.
And what did you find?
We learned that at the time...
in the Hearsack Foundation.
Sustained
Excavation of the grave site, was any other material besides that appeared to be wrapped around the remains located in grave A?
We located the victim's fingernails down on the bottom of the grave, the tire straps, the tie down, the electrical cord, the blanket, and then the victim's clothing.
Okay. Was there any towel-like or material located around the gravesite A, at least within a reasonable distance?
There was. It was visible around the area.
And would that have been documented by Ms. Radliff as well?
Yes, sir.
Okay, back here with Eric Johnson. Eric, do you find anything strange by the fact that the sledgehammer, which we believe might have been the murder weapon, was buried with the bodies? Our friend Joseph Scott Morgan calls that connectivity. I'm curious what your thoughts are that it was buried with the bodies.
Well, that is unusual. So you would think that by the fact that an instrument such as that sledgehammer being buried with the bodies, that it would have some connection to the crime. And that is possibly where the state is getting their foundation or their belief with regards to the blunt force trauma. And if that is what the state is contending, then the defense must focus in on making sure that there is no evidence to connect Mr. Merritt to that sledgehammer whatsoever. So we can concede, the defense could concede to the state that they were bludgeoned to death. However, that does not mean that Mr. Merritt did it.
Yeah, it's a good point, and especially since the only thing really tying is the fact that there might have been paint on the sledgehammer, which ties back to the house which was being painted. But again, then you have to try to connect Merritt to the house. It's a little complicated. We're trying to make sense of it. Let's keep going with Detective Edward Bachman, and we'll learn more about what was found in the desert.
There were a handful of different folks on both days.
Did Becky Burnell work with you on the 12th?
I believe that was one of the folks that was assigned on the first day, that's it, November 12th.
Mike Shea?
Yes, sir.
And Janine Rondon?
Yes, sir.
You guys measured the grave at some point when you were completed?
We did.
And it was 7'1", does that sound about right?
I think it was 71 inches.
Now, counsel showed you the picture of the soil depression before the excavation started.
Yes, sir.
That depression was measured in 3 different locations, was it not?
It was.
And you remember those measurements?
I think it was approximately toward the north end was roughly 3 inches. I think at the center, the way my report reads is, at the center it was roughly 4 inches, and then at the south end it was 6 inches.
Yeah. The next day, on the 13th, when you went back, the team was able to make more progress, obviously uncovering who ended up being Joseph McStay, correct?
That's correct.
And we saw some of the pictures for that?
Yes, sir.
Now, you talked about the body was wrapped in a cloth woven blanket.
Correct.
And that's how you described it in your report multiple times, as a cloth woven blanket, correct?
Yes, sir.
And the cord that was wrapped around Joseph McStay's neck.
Yes, sir.
Does that cord connect to the same cord that can be seen around the waist area?
It did.
And the cord around the neck, it was tied on the outside of the blanket, correct?
I would have to look at photos to say for certain, sir.
Now, there's mention of the tire compressions or depressions leading up to both graves A and B. Do you remember that part of the discussion?
Yes, sir.
Now, those tire depressions, they were measured at some point, were they not?
They were.
And were you present when they were measured?
I believe I was, yes.
And who was Heatherly Radliff involved in the measurement of those tire pressures?
I would say yes, because I believe I remember her taking overall photographs of the tape measure while the measurements were taken.
And were you involved in the measurement of those tire depressions going to both graves?
Yes, I would have been present while that was taking place.
And did you agree with the measurements, how they're being done, like the placement of the tape measure ends and the determination of the width?
Agreed, how so?
Like you didn't say, no, that's not right, that's not right. Were you agreeing with what everybody was kind of seeing?
I think based off of that, we were trying to take an approximate measurement. There was no tread pattern that was visible at that point, so we were trying to just take an overall approximate measurement of the actual impressions and stuff.
I understand, but did you state any objection to the process for which it was done or the determinations that were made?
I don't believe so, no, sir.
Okay, Eric, let's talk about the gravesite and what ties the defendant there. We believe that there is evidence that his cell phone might have pinged nearby that area just maybe days after the family went missing. There's also the idea that there were tire tracks that may match a car that he had been driving. Is that enough? Is that enough in and of itself to say, hey, he was there and he did this?
Well, no. One thing that you'd have to point out as far as if you look at the cell phone, the day that his cell phone pinged, the state has no evidence as to when the time of death was. So you don't know if his pinging of the cell phone was before the actual death or after. So therefore, this is totally circumstantial as far as it has nothing to do with the actual death. As it relates to the crime scene itself, I think that the defense really should have gotten each one of these crime scene investigators to talk about all of the factors that can contaminate a crime scene and make their readings unreliable as it relates to weather and all kind of stuff like that, and then focus on the fact that they didn't find the bodies until 3 years later. So all of these tire tracks, you can't say how many people have been over there in that time frame. You can't say how the weather conditions would have affected any of these things in a time frame. You can't say any of that, so therefore, everything that they're saying, as a defense, I would get them to admit is just a guess or a speculation prior to them leaving the stand.
Well, speaking of the conditions and of both, the desert and the bodies, are you surprised by this, that there's not more evidence linking him to this?
No, not surprised at all. I mean, the bodies were buried in a shallow grave in the desert for 3 years. I mean, so those bodies have totally decomposed. Any type of physical evidence that forensics could have wanted to find is gone at that point. So without there being something else linking him to it, either at the place of the death or, as you stated, with the car, I don't think that they have much showing that he's the one who actually did this. Everything is circumstantial, and if the defense can poke enough holes in their story, I don't believe the state has met their burden of reasonable doubt.
And what about the fact that the bodies were all buried together? Yes, there were two in one grave and two in another, but the fact that they were all together, does that tell you something?
It just tells me that whoever buried them there, buried them close by one another. It doesn't say anything as it relates to the manner of death. I don't think that a person who drove the bodies out to the desert is really going to want to take the time to find 4 remote locations to bury them. I mean, that's 4 separate burials. You probably want to get in there and get it done quick to bury the bodies and get up out of there. So I don't know, given that we don't know what factors were present at the time that they were buried, the fact that they're buried close together like that doesn't really say anything to the nature of the commission of the crime.
I think it's just a miracle that the bodies were found. And we're talking about the Mojave Desert, and 3 years after this family disappeared, it's a miracle that they were even found, and we're even trying to get answers to what happened to them. Let's take a break, though. When we come back, we're going to hear the testimony of Dr. Alexis Gray, who's a forensic anthropologist, and we're going to get some other interesting questions to ask. We'll be right back. We're talking about the Charles Merritt trial, where we will be live in at 12:30 p.m. Eastern Standard Time. Just want to let you know we're keeping a careful eye on that courtroom feed. But right now we're talking more about the evidence that was presented so far in trial. And we're talking about the murders of an entire family. We're talking about Joseph McStay, who was 40 years old, his wife Summer, 43 years old, and their 2 sons, Gianni, who was 4, and Joseph Jr., who was 3. Their bodies found in 2 shallow graves in the Mojave Desert 3 years after they disappeared in 2010. And then last week, we saw the testimony of Dr. Alexis Gray, a forensic anthropologist who was tasked with investigating and analyzing these remains. Let's see what she had to say.
Remains which then took a third, and then I had seen some remains sticking out that I thought probably indicated a fourth.
Okay. you indicated that you saw some remains sticking out. Do you recall whether they were sticking out at grave A or grave B?
Well, you would have to tell me which one we designated as grade A or grade B. I don't remember.
So if the one in front of you, if we looked at that and said that's grade B.
Okay, grade B, then it would be grade A.
Now, when you do this quick canvass, how worried are you about contaminating anything around you in terms of potential evidence?
Moderately. I mean, we have to weigh our need to get over a large distance versus preserving absolutely everything. In the desert, that's not possible anymore. So many factors have come in, from animals to weather to other people, coming through and all of that. The idea that you would have a pristine scene is something that you have to discard very early on.
Well, as you're walking around that day, can you tell us, you indicated that you saw tire tracks leading up to this particular grave that we see in the picture. Did you see other things indicative of animal activity?
Yes.
Did you see other tracks or things of indicative of maybe people riding dirt bikes or driving through there?
Yes.
Did you see other things indicative of footprints or anything like that?
I don't think I saw anything in terms of footprints. There was general cultural debris. Anytime you're out in the desert, there are cans and shotgun shells and all of this unrelated material that you kind of keep an eye on in case it turns out to be related, but most of the time you kind of walk past it, skirt it.
So as you go to this scene and you ultimately do this quick canvass, you indicated you are not dealing with a pristine crime scene at this point.
That is correct.
So if this is not a pristine crime scene, when you're walking around observing this, are you picking up items?
No, occasionally I'll pick up animal remains because I want to get them out of the field of play, if you will. Okay. And every once in a while you flip it over and make sure that you absolutely have an animal as opposed to some very unusual human.
Okay. I'm sure you've seen some unusual things.
I have.
Okay. So you determined that you're dealing with at least 2 adults and a child, and potentially another victim because you see something sticking out of the other grave, which we'll for now call grave A. What do you and Deputy Avery decide to do?
I asked him to call it in, and we asked for a deputy who can stand watch over the area until a recovery can be mounted the next day, because it was winter, and I think by the time we found the second grave, it was later. It was past 1, past 2, and you certainly couldn't mount something that large before it got dark.
That's my fault. I didn't ask you that question. Do you know approximately what time it was that you responded to the scene that day?
No.
Okay.
I want to say 11. It could have been 1. It was around lunchtime.
Okay. So then you had to drive.
All right, let's stay with the remains here. We're trying to understand more about where these bodies were discovered, and maybe we'll get some answers as to what happened to this whole family. But yes, Dr. Alexis Gray analyzed the remains, but what about who discovered them? That moves us on to John Bluth. He had discovered the bodies in the Mojave Desert. Let's see what he had to say.
How you handled that bone, if at all, when you discovered it or after you discovered it?
I believe I turned it over with a stick.
Okay. Did you recall ever touching it, manipulating it, picking it up, throwing it?
No.
Okay. Did you meet with law enforcement at the dump gate entrance?
Yes.
What happened after that?
He followed me over to. I had a long piece of a bush that I had placed so I can remember where it was. And he followed me to there, and I walked it in.
Him being a deputy?
Yes.
After that, were you involved in this anymore? Do anything else?
No, we walked in there, walked up and down the little rivulet, and then we went back to his car, and he called the forensic team because he wasn't sure too. And then we talked for a bit, and then he let me go.
You used a word, I don't know if I missed it or I didn't understand what you said, a rivulet?
Yeah, a little, like a channel where water goes through.
Okay.
a river, but you can tell water was going down a little. There's like hills.
Okay.
And this was a low point where that was.
Where water had flown?
What you believe was a human skull, you did not touch it?
No, not with my hand.
And when you found the human skull, you described you were in a rivulet. Is that right?
Can I object that he said one question and we're on two?
My apologies.
Well, I don't think it's like, not on a map, but just a contour of the land where it's a low point where water would go through.
And what were the weather conditions when you found what you believed was a human skull?
November-ish, partly cloudy, cold, windy probably a little bit.
And what were the ground conditions when you found it?
Dry.
I'm sorry, you said dry?
Yes.
You found what you believed was a human skull. You did not touch it?
No, not with my hand.
And when you found the human skull, you described you were in...
All right, Eric, let's break this down right now. First question I have, seems a bit strange that Joseph McStay was the only one wrapped up in something. And in fact, he was the only one who had this electrical cord apparently wrapped up around his neck. What do you make of that?
Well, I think that most likely that would probably mean that the person who was trying to transport his body probably couldn't do it, and they needed to wrap that cord around there to get them to move the body, which how that plays out as far as how the crime was perpetrated possibly indicates that there may have been more than one person involved, which helps Mr. Merritt in this situation. But the fact that the body was wrapped up in the electrical cord, unless they're trying to say that he was strangled to death with it first and then dragged out there, is really just a minor piece of evidence.
But wait a second. We're talking about the deaths of 4 people, right? And we're also trying to understand practically how this happens. Does this give you a sense of perhaps he was killed first before the others, or he was killed last? I mean, can we glean anything from this?
Well, I mean, what it could possibly be is that he may have been killed first, but given the fact that you have a family in this situation, you would probably assume that the father would have been killed first, as he was probably trying to protect his family in this situation. So he may have been the one that was killed first. So if that was the case, then it would have been easier to manipulate the wife and the kids out of the fear and the shock of just seeing that their father and husband was being killed. So it is definitely a possibility. But once again, the order of death still does not prove Mr. Merritt's involvement in the case.
Well, let's think about this. If Mr. McStay Sr. was the intended target, which is what the prosecution wants to say, that they wanted to get rid of McStay so he could, Merritt could take advantage of those funds. If he was the intended target, maybe that's why there's a difference between the way he was found and the rest of the family, because one of the theories is maybe that the family wasn't supposed to be killed, but they got caught up in it.
That is definitely a possibility. But however, if that is the case and that Mr. McStay was the only one, then it gets back to who also had a motive to do it, and the fact that Mr. Merritt was not the only individual, and it could be possibly somebody, including Mr. Kavanaugh, or anyone else, based on how the defense wanted to develop that line of questioning, goes to the fact that there may have been somebody who wanted to kill Mr. McStay for some reason, but it does not necessarily tie Mr. Merritt into it.
Eric, I think we only have about, we have about a minute left. So my quick question to you, how much does the defense have to prove that Dan Kavanaugh did this?
They don't. All they have to do is to present the possibility that there is someone else who may have done this, as well as pointing out the fact that the state does not have any evidence tying it in. The Kavanaugh is just the cherry on top. The fruit of this Sunday for the defense is pointing out the fact that the state does not have a whole lot tying Mr. Merritt into it. The introduction of Kavanaugh is just to try to push the jury over the edge in the finding that there was not reasonable doubt established by the state.
Eric Johnson, thanks so much from your perspective and making an amazing dessert reference nonetheless. So thank you so much. We really appreciate it.
Thank you. Have a great day.
You too. Okay, everybody, we're going to take a break. When we come back, we're going to talk more about the Charles Merritt case. And again, we do expect to be live there in about an hour and a half. We're keeping a careful eye on the courtroom feed. So we'll take a quick break. We'll be right back here on Law and Crime.